Okay, let's unpack this. Today, we're diving deep into a really fascinating and honestly a pretty high-stakes intersection of artificial intelligence, robotic process automation, and U.S. patent law.
It's a huge one.
Yeah, and this isn't just some dry administrative stuff. We're looking at a landmark decision from the Patent Trial and Appeal Board, the PTB, that really gets to the heart of how innovative AI is protected.
It really does. I mean, for anyone in software or fintech or automation, this is essential. The question here is so fundamental.
Right.
It's, when you build an AI system that uses multiple layers of machine learning to hit a business goal, is that a patentable invention? Or is it just, an abstract idea that you can't protect?
And the source we're pulling apart is the ruling in Ex parte Prabhdeep Singh and Michelle Yurovsky. It's a huge deal because it's a total reversal of what the patent examiner first decided.
And it gives us a real roadmap, I think, for how inventors can successfully frame these kinds of software inventions.
So our mission today is to get past that headline, rejection overturned, and really get into the granular legal reasoning.
Exactly. We want to know how the claims were written to get past the finish line, and maybe more importantly, why the examiner's arguments just didn't hold up.
Okay, so to get us started, let's just lay the groundwork. With these kinds of rulings, the metadata is everything. We need to know the who, what, where, and when.
Absolutely. So this decision came from the United States Patent and Trademark Office. Specifically, it's from their internal judicial body, the Patent Trial and Appeal Board, or PTAB.
Which is basically the highest court inside the patent office itself, right?
That's right. It's the end of the line for appeals within the USPTO.
And what are the numbers we should be tracking here? The case file and date.
So the appeal number is Appeal 2025-001269. It's for patent application 116,107,763. And the really important date, the date of the decision, is October 34, 2025.
Okay, so it's a very recent decision.
Very. And even though it's an administrative ruling, the reasoning pulls directly from federal circuit law, which gives it a lot of weight for other examiners.
So who are the people appealing? And I think more importantly, who is the company behind them?
Well, the inventors, the appellants, are Prabhdeep Singh and Michelle Yurovsky. But, and this is the key part, the decision names the real party in interest as UiPath, Inc.
UiPath. Okay, so that immediately raises the stakes. They're a huge player in robotic process automation.
A global leader. So this isn't some academic patent. This is about protecting core commercial technology for a market leader.
So this was a strategic move. They're trying to lock down a key piece of their tech.
Precisely. For a company like UiPath, patenting the method for finding and improving automated processes, well, that's arguably more valuable than patenting the robot itself.
It's the brain of the operation.
Is the brain of the operation, you got it.
And who are the judges on the panel that made this call?
It was a 3-judge panel. The decision was written by Administrative Patent Judge B.B.U.R. Mohanty, and he was joined by judges James P. Key L.V. and Robert J. Silverman.
And they were reviewing the rejections from
examiner Scott M. Ross. He's in Art Unit 3623, which, is a unit that specializes in this exact area complex computing, data processing, and AI.
So he should have known his stuff.
You would think so.
Uh-oh.
And just to round it out, the law firm that successfully argued the appeal for the inventors was Leonard Patel, PC.
Okay, that gives us the full picture. Let's pivot now to the tech itself. The field is RPA, but what was the actual invention here? What problem was it trying to solve?
So the invention is all about robotic process automation. And just as a quick reminder, that's where you have software bots that mimic what a human does on a computer to get tasks done.
Right, like filling out forms or moving files. But historically, setting that up is very manual.
Incredibly manual. Someone literally has to watch a process, map it out, and then build the bot. It's very labor intensive.
And that's where this invention comes in.
Exactly. This is in an area called process discovery or process mining, but supercharged with AI. The invention is about analyzing just massive amounts of data, keystrokes, mouse clicks, logs, how existing bots are performing.
So all the digital breadcrumbs of work.
All of them. And then it uses sophisticated AI to automatically figure out what the processes are, how they flow, and this is the critical part, how to improve the existing robots.
And what was the stated goal of all this analysis? What was the outcome?
The key outcome, and they hammered this point home again and again, was generating a workflow specifically for return on investment improvement. ROI.
Okay, so it's not just finding a process. It's finding a better, more efficient process tied to a measurable business result.
A technical business outcome. That's a really important distinction.
Let's break down the actual claim. Claim 1 is the big one. It had, what, 5 main steps?
That's right. The first few steps are about data collection, the technical setup.
Hmm.
First, you deploy listeners' little software agents onto computers.
Oh,
Second, you collect the data from user interactions, or the robot's performance. Third, you store all that data. Pretty standard so far.
right, the setup.
But step 4. Step 4 is the heart of the invention, and it's where the whole legal battle was fought.
And that was in ELA?
Analyzing the stored data using artificial intelligence by running the stored data through multiple AI layers to discover processes or improvements that improve return on investment, ROI.
Multiple AI layers. That phrase feels very deliberate. Why not just say using AI or using machine learning?
It is incredibly deliberate. It's both a technical and a legal strategy. You see, multiple AI layers suggest a complex structure, not just one model doing one thing.
So you're talking about like one AI layer figuring out what's on the screen and another layer figuring out the most efficient way to click through it.
That's a perfect example. One layer could be a deep learning network for visual recognition, feeding its output into a reinforcement learning model that optimizes the sequence for speed. And the whole system is geared toward that ROI goal.
So that complexity is what they're using to fight off the abstract idea charge.
It's their main weapon.
And what was the final step in the claim?
The final step is what ties it all back to the real world, so to speak. It's generating a workflow that implements that new, improved process, and that workflow is configured to be executed by an RPA robot.
So it takes the analysis and turns it into an actual set of instructions for a machine.
A concrete technical transformation. You're not just getting a report. You're getting a new, functional piece of software.
Got it. Okay, so the application was filed back in December 2019. It took almost 6 years to get this decision. So what were the roadblocks? What did the examiner, Mr. Ross, have a problem with?
Well, he threw up the two biggest hurdles you see in almost every software patent case. The whole thing boiled down to two legal questions for the PTAB.
Which were?
1. Patent eligibility.
Mm-hmm.
Under Section 101, was this invention just an abstract idea dressed up in computer jargon?
And
2. Obviousness. Under Section 103, even if it's eligible, would the invention have been obvious to a regular engineer in the field based on what was already out there?
let's take the eligibility challenge first. The Section 101 rejection. How broad was it?
It was a kill shot. He rejected all 20 claims, said every single one was directed to an abstract idea without adding anything significantly more.
So if that stuck, the entire patent would be dead.
Gone completely.
And the second rejection, for obviousness, that was based on combining other existing technologies, right?
Right. He was basically trying to Frankenstein the invention together from pieces he found of the prior art. The main combination he used against most of the claims was a mix of three references: Goyle, Kakandiki, and Kahandaraman.
Okay, so what were those pieces? What was he trying to stitch together?
Well, his argument, and we'll dig into this more, was that Goyle gave you the idea of analyzing data with predictive models.
Okay.
Kakandiki gave you a general framework for optimizing processes, and Kahandaraman gave you the idea of using multiple AI models.
So the examiner's logic was, take this, add that, apply it to RPA, and voila, you've got the invention. It's obvious.
That was the argument. He saw it as just an obvious combination for any skilled engineer to make.
So that sets the stage perfectly. You have the inventor saying this is a novel, eligible, complex AI system, and you have the examiner saying, no, it's an abstract idea, and even if it wasn't, it's obvious.
And that's the conflict the PTAB had to resolve.
All right, let's get into that legal analysis, starting with the big one, the patent eligibility battle under Section 101.
This is really where the action is, because this is where the vast majority of software patents live or die. The PTAB starts by confirming they're using the standard two-step Mayo-Alice framework from the Supreme Court.
Right. Can you just quickly walk us through that framework again? Step 1 and Step 2.
Sure. Step 1 is basically a filter. It asks, is the claim directed to one of those judicial exceptions, a law of nature, a natural phenomenon, or an abstract idea?
And if the answer is yes?
Then you go to Step 2. And Step 2 asks if the claim as a whole has an inventive concept that's enough to transform that abstract idea into a patent-eligible application of the idea.
The significantly more test.
That's the one. Is there significantly more than just the abstract idea itself?
So, applying that, what did the examiner say at Step 1?
The examiner concluded that, yes, the claim was directed to an abstract idea. He basically categorized it as a method of organizing human activity or a mental process.
So he saw it as just analyzing data to improve a business, which is a concept.
Exactly. He stripped away the technology and said the core idea is just analyzing information to get a business result like ROI, and that's abstract.
A classic problem for software patents. The idea of analysis is abstract. The whole game is proving your method of analysis is not. So what was the counter-argument from Singh and Yurovsky?
They had a really smart three-layered defense. First, they argued it wasn't abstract at all. They said it's inherently technical because it's about controlling computers and RPA bots, making it a practical application.
So they challenged step one directly.
They did. Then, as a backup, they said, even if you think it's abstract, it's integrated into a specific tangible process. But their strongest argument, the one they really leaned on, was the third one.
Which was the significantly more part.
Precisely. They focused all their energy on step two, arguing that the claim contained way more than the abstract idea and that more was found in the specific technical details.
And it seems like the PTAB decided to just jump right to that part of the argument.
They did. They basically said, okay, let's assume for the sake of argument that this is directed to an abstract idea. They confined their whole analysis to step 2B, the significantly more test.
And why is that move so important?
Because step 2B is a factual inquiry. It's not a question of law, it's a question of fact. It asks whether the extra stuff in the claim is well understood, routine, and conventional in the industry.
Which brings us to the case that changed everything in this space. Berkheimer. Why was Berkheimer such a big deal here?
Berkheimer VHP was a bombshell because the Federal Circuit established that whether something is well understood, routine, and conventional is a question of fact.
And making it a question of fact shifts the burden of proof, doesn't it?
Completely. It means an examiner can't just wave their hands and say, oh, using a computer for this is conventional.
Yeah.
The Berkheimer memo from the USPTO now requires them to provide express written support.
They need to find a citation, an admission, something concrete to prove it's routine.
They need to show their work. They have to provide actual evidence. Conclusory statements are no longer enough. And that was the fatal flaw in the examiner's argument.
So the inventor's whole strategy was built around this. They claimed something so specific, that combination of multiple AI layers and ROI improvement, that they dared the examiner to find evidence that that exact thing was conventional.
That's it exactly. They focused laser-like on that limitation, running data through multiple AI layers to discover processes that improve return on investment, ROI. And they argued that the examiner had provided zero factual evidence to show that this was conventional.
So how did the examiner try to push back against that? How did he argue that multiple AI layers was actually just generic and routine?
He basically tried to downplay its significance. He called it a broadly recited additional element that just links the abstract idea to a computer. He was trying to frame it as just a generic tool being used to perform the abstract task of data analysis.
So in his view, multiple AI layers was just a fancy way of saying computer, and since using computers is conventional, the claim fails.
That was the logic. But he didn't provide any prior art showing that specific layered structure being used for RPA process discovery with an ROI goal. And the PTAB saw right through that.
Okay, let's get to the PTAB's decision on the 101 rejection. What was the final holding?
It was clean and simple. We reversed the rejection of Claim 1 and all Claims 120 under Section 101.
A complete reversal. And the reasoning?
The reasoning is the key takeaway here for anyone drafting these kinds of claims. They said the rejection fails because the examiner did not show that the claimed invention was well understood, routine, or conventional. He failed to meet the factual burden that Berkheimer requires.
So the unique combination of the elements, the multiple AI layers, the RPA context, the ROI goal, was what saved it.
Yes, the PTAB made it clear that you have to look at the combination as a whole, and the examiner had provided no evidence that that combination was conventional.
So the message is, if you're claiming an AI invention, you have to be incredibly specific about the architecture and its application.
You have to. You have to write the claim in a way that forces the examiner to find something that matches that specific structure and function. If they can't, under Berkheimer, the claim should be allowed. It's a powerful shield.
Okay, so a huge win on eligibility. But they still had the other rejection hanging over them. Obviousness under Section 103.
Right. Winning the 101 battle is often just the first half of the game. The examiner's backup argument was that the invention was obvious based on that combination of Goyle, Pakandiki, and Kathandaram.
And the core of an obviousness rejection is that a skilled person in the field would have found it obvious to combine those things, right?
Exactly. That a person of ordinary skill in the art of POSA would have been motivated to combine them.
So what was the appellant's argument against that? Why did they say that combination was improper?
They attacked the very logic of the combination. They argued that the references were aimed at solving completely different problems, so there would have been no reason or motivation to put them together. They called it impermissible hindsight.
Let's break that down. What was the Goyle reference all about?
Goyle was focused on failure prediction. It's a system designed to predict when a process or a part of a system is going to fail. It's about risk mitigation, not optimization.
Okay, so it's a defensive tool. What about Kakandiki?
Kakandiki was much more general. It was described as a functional process optimizer. It teaches broad principles of how to make processes better, but it's not tied to this kind of sophisticated, multi-layered AI discovery.
So the inventor's argument was, why would an engineer who's trying to build a system to find new and optimal processes for ROI improvement
Right.
start by looking at a reference that's all about predicting failure?
Exactly. They argued there's no logical bridge. Why would you combine a failure prediction model with a general optimizer and then apply multiple AI layers to it, all to solve the problem of ROI-based process discovery? It only makes sense if you already know the answer.
It only makes sense in hindsight.
In hindsight, that was their whole point.
And this brings us to the big Supreme Court case for obviousness, KSR. How did that play into the PTAB's decision?
The PT leaned heavily on KSR International v. Teleflex. KSR is critical because it says an obviousness rejection can't be based on mere conclusory statements. There has to be some articulated reasoning with some rational underpinning to support the conclusion.
So just like Berkheimer requires facts for eligibility, KSR requires a clear rationale for obviousness.
That's a great way to think about it. The standards are very similar. The examiner can't just say it would have been obvious. They have to explain why. What was the motivation? What problem in the field would have led someone to make this specific combination?
And the PTAB found that the examiner's reasoning was lacking.
They found it was completely lacking. They said the examiner failed to show why a skilled person would have been motivated to combine a failure prediction tool with a process optimizer to achieve ROI improvement in RPA. There was no articulated reasoning.
So the whole argument just fell apart.
It did. The PTAB basically said the examiner's logic relied on hindsight. He started with the invention and worked backward to find pieces that could fit without ever explaining the initial motivation to put them together.
So what was the final holding on the 103 rejection?
Another clean sweep. We reversed the rejection of Claim 1 and all remaining claims under Section 103.
So they won on both counts. They held the examiner's feet to the fire on the high standards set by Berkheimer and KSR, and the examiner's arguments just didn't measure up.
That's the story. A total victory based on forcing a strict adherence to legal precedent.
Okay, let's synthesize all of this. This was a complete win for the inventors. All 20 claims reversed on both 101 and 103 grounds. The application now goes back to the examiner, presumably for allowance.
Correct. It was a clean sweep.
So let's just listen to that one more time. What were the key statutes and the critical court cases that made this happen?
Sure. The statutes, of course, were 35 U.S.C. Section 101 for eligibility and Section 103 for obviousness.
And the precedents.
For eligibility, the framework is Alice and Mayo. But the case that really did the work was the Federal Circuit's decision in Berkheimer v. HP, Inc. That's the one that established the factual burden for conventionality.
Then for obviousness.
It was all about the Supreme Court's precedent in KSR International v. Teleflex. That's the case that demands articulated reasoning and a rational motivation for combining references.
Was this decision unanimous among the three judges?
It was. The source material shows no dissenting or concurring opinions. It seems the panel was in complete agreement that the examiner just hadn't met the factual and reasoning burdens required by the law.
Okay, so this brings us to the big question for everyone listening. What is the real-world legal significance of this? What does it mean for the AI and RPA industries going forward?
I think this decision is an incredibly valuable guide for how to draft AI-related patent claims, especially for these complex layered systems that produce a specific technical result.
So for the Section 101 eligibility part.
For Section 101, this is a powerful reaffirmation of the Berkheimer standard. It tells us that if you claim a complex AI structure like multiple AI layers, an examiner can't just dismiss it by saying using AI is routine.
They have to prove that specific structure for that specific purpose is routine.
Exactly. They have to provide specific cited evidence that, for example, using layered AI for RPA ROI optimization is conventional. And that's a very high bar. It protects sophisticated AI systems from being tossed out as abstract ideas.
So the lesson for inventors is be specific. Don't just say you used AI. Describe the architecture, describe how it works, and link it to a concrete technical problem.
You've got it. You have to make the idea inseparable from the non-conventional technology you use to implement it.
And what about for Section 103 for obviousness?
It reinforces that the PTAB is going to be very critical of rejections based on combining references that have different purposes. You can't just mix and match technologies. There has to be a clear, non-hindsight motivation for it.
Which is great news for companies like UiPath.
It's a huge commercial win. It means their investment in building these advanced process discovery algorithms, the brains of their platform, is protectable. It gives them a defensible moat around a key piece of their technology.
That puts it all into context. So if we had to boil this entire deep dive down to one single most important key takeaway, what would it be?
The single most important key takeaway is this. The PTAB is making it crystal clear that the USPTO has to rely on specific, factually supported evidence and articulated reasoning. General conclusory statements are not enough to defeat a patent claim, whether on eligibility or obviousness grounds. The burden of proof is firmly on the examiner.
And when they can't meet that burden, as we saw here, even complex AI claims will survive.
They will stand.
This has been an incredibly insightful look at a decision that really matters. We've seen how smart claim drafting using specific language like multiple AI layers and a deep understanding of legal precedent like Berkheimer and KSR can lead to a complete victory.
It's a masterclass, really, in patent strategy. It shows inventors that they have to define a clear technical problem and a unique technical solution that goes way beyond what a generic computer can do. If you can define the complexity, you make it very, very hard for the patent office to call it conventional.
Right. And this decision really does clear a path for patenting these kinds of advanced layered AI systems and automation. But that brings up a final provocative thought for you to chew on as you see more and more AI products out there. We saw today that multiple AI layers was enough to be considered significantly more. It's not routine and conventional yet. But what happens in a few years when the next generation of AI tools can create these kinds of specialized, multi-layered models almost instantly?
Yeah, when it becomes accessible to everyone with a click of a button.
Exactly. At what point does today's cutting-edge innovation, the very thing that makes a claim patentable, become tomorrow's routine and conventional technology?
That boundary is always moving, isn't it? And you can be sure the patent system is going to be chasing that line for a long, long time, trying to figure out what true invention looks like in an age where algorithms themselves can create.
Something to think about. Thank you for joining us for this deep dive into the fascinating world of AI patent law. We'll catch you next time.